review, which is what we all want to avoid if possible, where people are dissatisfied with the outcome of an application. And obviously, you know, we can't, as you've already heard in terms of economic analysis alone, we can't unfortunately give everything, every treatment that every patient requests. So I'm going to try to run through this as quickly as I can, picking out the legal and ethical points. So I'm going to talk first of all about the appropriate way to challenge these things. You know, some people say, well, why can't you bring a negligence claim? Well, the answer is you can't challenge the decision of a public body by bringing a negligence claim. You have to do it by way of judicial review. So then I'm going to talk about grounds for judicial review, and I hope how to avoid it if you possibly can. You know, we all know, and we've heard already, and I don't want to repeat what other people have said, that resources are limited. There's no bottomless purse, and therefore clear guidance is required for decision makers to adhere to. In IPFR, although the focus is on individual patients, that has to be seen in the context of the limited resources and viewed in the light of availability of treatments for everybody else. So it's much more complicated than just looking at each individual patient. It's interesting to note that in the All Wales panel, 7 out of 10 applications are approved. So just to turn to the policy, and the policy is absolutely crucial. You must understand the policy in order to avoid judicial review of your decisions. And, you know, there we have the obvious statement that, you know, you have to strike the right balance between providing services to meet the needs of the majority of the population, while still having in place arrangements to accommodate individual patients' needs. And there in bold, you see, to manage this aspect of the Health Board's responsibility, and the same applies across the All Wales panel, there will always be a need to place a robust process for a robust process considering requests for individual patient funding. So let's have a look at the policy. How are we defining IPFR for a start? Sorry. IPFR requests are defined as requests to a health board or WISC to fund NHS healthcare for individual patients who fall outside the range of services and treatments that are routinely provided or commissioned. And this can include any type of healthcare, you know, as you will all know, because you all have an interest in this. It may be a specific piece of equipment or a certain treatment or perhaps a drug or a service. And those requests normally fall within 3 categories: a new, developing or unproven drug, for example, which has not yet been approved by NICE or may never be, or there's no evidence base, and evidence is absolutely crucial to decision making. Or there may be, it's a treatment such as a bespoke wheelchair, which is not routinely commissioned, or the patient's condition doesn't meet the policy criteria. So, for example, there's an age limit for fertility treatment. And I think you already know that from that little, very interesting, I thought lovely, activated sort of almost cartoon that we saw, clinicians have a duty to inform their patients honestly about the details of the proposed treatment and answer any questions. And then the patient and the clinician must agree together that a request should be made. It's not on for a clinician who fancies trying out a particular treatment on a patient simply to go ahead without involving the patient in the process. The requesting clinician has to sign the form to indicate that the patient is aware and agrees with the submission. So you know that already, and that is really good. So if the patient is dissatisfied, then, as I've said already, the appropriate action is a claim for judicial review. So you challenge, because this is a public body making a decision, the challenge is by way of going to the court and asking the court to review the decision. And the grounds for judicial review, you have to, have grounds in order to bring any claim, really, are error of law, making a mistake in the application of the law, abusing powers or going beyond the powers that you have, taking irrelevant considerations into account, or failing to take relevant considerations into account. So that would amount to irrationality, or placing an unlawful limitation on the discretion to take into account the matters under consideration, improperly delegating decision-making, or being biased, acting contrary to the rules of natural justice. If someone on the panel is related to a person, for example, whose clinician is applying for them to have a particular treatment, or failure of an organization to follow its own policy. So we must all be very careful to ensure that we do follow our own policy. Now, I haven't added to that it might be possible, although these applications almost always fail, to argue that the Human Rights Act has not been complied with. And I'll come to that in more detail in a minute. So the judge in this case here in 2017, re SB, or SB against the NHS England, explained that interpreting a policy to see if the policy is lawful is a matter for the court, but applying the policy is a matter for the decision maker. And that is why we are regularly provided with copies of the policy. I believe one has been attached to today's papers. The judgment that is made by the decision maker must be formed on the basis of understanding the available evidence and taking all relevant factors into account. So the evidence base is absolutely crucial, and if we don't understand it, we must, and we do, go back and ask for it to be explained by those who do. So if it's evidence about a new drug, for example, we would want to see what has been published in the various journals, and the level of the journal that's agreed to publish any results of research. And even if the decision is actually, in the view of the court, the decision itself is wrong, then irrespective of its own views of, that is the views of the court, of the merits of the decision, i.e. is it a good decision or a bad decision, the court is not entitled to substitute its own decision for that of the panel that made it. There is one case I can think of, which is one of the very, very rare examples where the court said there is only one rational decision, and they did substitute their own view. I'm not sure that was a good move on the part of the judge, but never mind, it's not for me to argue with that. So what do we mean by good decision making? And we've all seen these factors issued by Welsh Government. It must be open and transparent. It must be inclusive. We must all be accountable for our decisions, that our decisions must be reasonable. They must take into account effectiveness and efficiency. And we must all be aware of the duty of care that we owe in decision making. So it must be lawful, and there must be a right of challenge and appeal. And we're all aware of those, I hope, but not maybe explicitly taking them into account every time we make a decision. So how can we avoid judicial review? And that is the crucial question. And actually, it isn't that difficult, as long as we are conscious of adhering to the policy at all times. So having the policy in front of us when we make decisions is a good idea. And while we're adhering to that policy, we must also take all relevant considerations into account. So logically following the policy and staying within the tramlines, not straying outside them, is crucially important. So we mustn't take irrelevant matters into account. And I'll come back to that business of social personal circumstances, because those are, according to our policy, irrelevant. We must make evidence-based decisions, but we have to be flexible because there could be fresh evidence introduced almost, in the course of the decision being made, and obviously take expert advice if necessary on the evaluation of evidence. We are not absolute experts on evidence evaluation, but there are people we can call upon who are. And I think it's very important to be compassionate because these patients are, many of them, desperate. Many of them are going to die if they don't have the treatment they want, but we have to be detached. So I think it's very important to express regret for outcomes that will be disappointing for the patient. And then especially give clear reasons for the decision. Public bodies are expected to give clear reasons. And there we have, again, from the policy, the decision-making panel should have regard to. Evidence should be presented to demonstrate the expected significant clinical benefit, and the evidence presented outlining the patient's individual circumstances. Decisions should be taken whilst taking into account the evidence base and the economic and ethical factors listed below. So we're only talking about clinical circumstances, not personal circumstances. And again, back to evidence-based considerations about the cost and clinical effectiveness and the implications, the wider implications. Economic considerations you've heard all about, and I'm not going to go over that. You had a lovely, clear presentation about that. And then ethical considerations, and I'm going to talk about those next. But the three tests that we apply are, has the clinician stated clearly in the application why the clinical circumstances of the patient are significantly different, and that word significantly is important, to the general population of patients for whom the recommendation is not to use the intervention. And the general population is a population for whom this procedure would be equally suitable at the same stage in the development of the condition. And those of us who are experienced know what that means, but even those of us who are experienced need to keep coming back to that. And then the second test, the significantly more clinical benefit test. If the patient meets the criteria in the first test, the next question is whether it's likely that the patient will gain a significantly greater clinical benefit from the treatment than other patients with the same disease and at the same stage. And then we have the reasonable value for money test, which is very important. And I'm not going to dwell on that because we have had, as I said, a good presentation on it. But you weigh up the cost of the treatment when compared with other alternative treatments, and so on. At each stage, and this I think is very important because we often miss this, at each stage, and possibly separately at the end, because there is a box to fill in on that, the panel should take into account any ethical principles and ensure that these are stated explicitly in the notes of the meeting and, if possible, in the letter to the clinician. The ethical principles and underpinning policy, I'll come to, but treating populations and particular people with respect is always important, minimizing the harm that an illness or health condition would cause, fairness, working together, keeping things in proportion, and flexibility. So anyone who's ever done medicine, and I think nurses as well, will have come across Beecham and Childress, their book, Principles of Biomedical Ethics. It was written quite a long time ago now, in the 60s, I think, and there've been updated editions ever since. But they identify 4 principles. Autonomy, that is taking into account the right of a person to determine their own future and make their own decisions. Beneficence, doing good. Non-maleficence, that is not doing bad things to people, not allowing them to be experimented on, for example, and justice, that is equality and considerations of that kind. I wanted to talk now about a case called Conliffe against Staffordshire PCT, decided in 2011, because it's very relevant to what I'm talking about. And this was a case which was brought by way of judicial review and got as far as the Court of Appeal, in which a morbidly obese patient said that the PCT had been wrong because it had failed to take account of social factors and personal factors and family matters, matters that were really important to the individual. And the policy itself said that, you know, you should not take social or non-clinical factors into account. And if we look back at the Beecham and Childress principles, we wonder, I wondered when I read this, really whether what we've been doing was correct, because, you know, how are we taking account of a patient's autonomy if we're not even looking at their family circumstances? How are we doing good to that patient? How are we avoiding bad decisions for the particular patient? And how is this just? So, in fact, what the court decided, I'm sorry, that's my last point. I'll go back to this one. What the court said was that the arguments put forward on behalf of the patient, which were based actually on Article 8 and Article 6 of the European Convention of Human Rights, did not apply in this case, in cases of this kind. It is perfectly permissible, the Court of Appeal and the court below decided to have a policy which does not take account of social or non-clinical factors, because although Article 8 is important, Article 8 is about protecting family life, and, you know, your personal position in the world, if you like, that Article 8 is not necessarily imposing, or in fact, it does not impose a positive obligation to take account of these factors. So, you know, there is no obligation, if you like, to take account of these positive factors. So what we need to be saying is it is actually permissible to have a policy which says you can only decide on the basis of clinical factors. And because that was decided by the Court of Appeal, obviously it's been followed in later cases, the Court of Appeal being very high up in the hierarchy of the courts. Article 8 is not engaged in many of these cases. It cannot therefore even be invoked. And Article 6 is the right to a fair trial. Well, because the case failed on the Article 8 point, Article 6 also was not relevant, which means that many cases where people have tried to argue, even when a patient's life actually is at stake if they don't have the drug for which is being applied for on their behalf, or the treatment, those cases are going to fail simply because the Human Rights Act, those two basic articles of the Human Rights Act, which might be relevant, are not engaged and cannot be invoked. So hopeless to argue, really, although it's tried over and over again